Hi, it's Caitlin Jenkins here, the Family Law Vlogger. This is the latest in the stages of divorce series. This one is about section 2.14 of the Form E, which is capital other assets. So you're filling in your Form E, whether you're doing it for mediation or voluntary disclosure or for the court process, you've got to page 2.14, which says capital other assets. Now, what falls into this category? Well, basically it's a catch-all. So any other capital asset that you haven't included elsewhere in your Form E will probably go into this section. So if you look back at the Form E and think, well, I've got this other asset or another interesting asset, perhaps put it into that section so at least it's complete. What particularly tends to go in 2.14? Well, a couple of things. One is share options. So if you have shares, say you work for a company, they pay you a salary, maybe they pay you a bonus, and they give you some shares as part of your bonus, then the salary and bonus will go into the income section. The shares would go in an earlier section of capital assets. There's a section that talks about shares. But share options otherwise wouldn't appear in the form. So share options are where you're given a right to acquire shares at some point in the future at a future price, usually as part of the bonus package. So if you have share options as part of your employment, then you'll probably know that this is the section where this needs to be included. The sort of information you're likely to include is the number of share options, the date they were given to you, the price they were awarded, the vesting date and the vesting price, and preferably any tax consequences if you do then acquire the shares in the future. So share options is probably a specialist area. If you haven't got a solicitor, it probably is an area where it's worth getting some advice from a solicitor before you complete the form, because it's a complicating area to put a value on share options as to now what they might be worth in the future, what the tax consequences are. So share options fall within 2.14. The other area that often falls within 2.14, which again is probably an area for specialist advice, is if you have an interest in a trust. So if you have an interest in a trust, whether you're the settlor of a trust, whether you're the beneficiary of a trust, then particularly if you're a beneficiary, you're going to need to disclose that in this section. If you're the settlor, so the person who set it up, or the trustee, you may still need to disclose it in this section. It depends on the terms of the rest of the trust, but primarily, and in particular, whether you're also a beneficiary. But certainly if you're a beneficiary, even if just within a class of broad beneficiaries of a discretionary trust, you're going to need to disclose the background and the details to that trust in this section. Again, specialist area as to what you disclose, what value, if any, you put on that trust interest, whether there is a value to it, and also what documents you should attach. So trust interests and share options often go in 2.14, and I would say is an area that would indicate that you do need specialist advice before you fill in your Form E. And then the final area, apart from a sort of catch-all of somewhere that you haven't put anything else, another asset in, is an asset that somebody's holding for you. So say you've gifted an item to somebody, but it isn't a gift really, it's an item that they're holding for you and there's an agreement they're going to give it back to you, but it isn't in your name, so it's not a joint bank account that would appear in the bank account section, then that may well go into that section too. As I say, 2.14 is one of the particular areas that actually, if you think you've got an asset that might fall within a category within 2.14, you may well be wise to get some specialist advice so that you present your assets as fully as possible, given in particular that full and clear financial disclosure is a key stage in the disclosure process and in the process by which you can reach an agreement on the finances. And also given as part of that, you're going to sign the form to say that it's true. So you want to make sure that you're disclosing things fully and accurately, and also in the best way possible to present your case. So that's section 2.14. As always with the Family Law Vlog, if you want advice on your specific circumstances rather than the general information that the vlog provides, then please do contact me or one of my specialist colleagues in the Mills Reeve Family and Children team, whose details will be underneath this vlog. Thanks very much.